I went to Vietnam in 1966, August of '66, with the 173rd Airborne Association. I was attached to a platoon that was operations. We did a lot of what's called LRP, long-range patrol type operations. And in that 6-month period that I was there, I was shot 3 different times. The last time I spent a year and a half in the hospital.
And you're Airborne Ranger, Pathfinder, Jungle, and Sniper School, right?
That's correct.
And that may not mean a lot to a lot of people, but it means a lot to me. Did you win any awards over there?
Yes, I did.
Did you win the Purple Heart?
Yes, I did.
And there's a bunch of other awards, but the biggest one is the Distinguished Service Cross. Did you win that?
Yes, I did.
That's the second highest ranking award you can give below the Medal of Honor.
Right. I wouldn't say I won it. It was awarded to me.
Yeah. Did you, subsequent to your discharge from the military, what did you do then?
I went back to school after the military and got my bachelor's degree, and then I went into the FBI.
When did you enter the FBI?
I entered the FBI in April 30th of 1973.
When you first came in, what were your primary duties?
After the academy, I was assigned to Chicago, and in Chicago I worked criminal matters and then foreign counterintelligence for about a year.
Have you ever done any investigations with the FBI of violent crime?
Yes.
Could you elaborate on that before?
Well, some of the work that we did in criminal matters in Chicago was violent crimes. And when I went to New York, I was there in New York for approximately 8 years. We worked several different violent crimes. I was on the SWAT team. I was a firearms instructor, defensive tactics instructor, and a pilot, fixed-wing pilot, and did a lot of other things. But we did a lot of violent crimes investigations.
Have you been certified by the FBI as an instructor?
Yes.
In what areas?
In several areas, firearms instructor being one, defensive tactics instructor, bomb school instructor, sniper school, hostage negotiations. God, there's a lot of them that I never paid attention to because I didn't work in that much.
Did you ultimately become a supervisory special agent for the FBI?
Yes, I did.
Okay, tell the court about that.
When I came to Quantico as an instructor, I was automatically at that point made a supervisory special agent. I worked in the SWAT program for approximately 8 years. The SWAT program was one of my areas that I instructed in, and I ran the school for approximately a year and a half. I was a sniper school instructor, and I ran that program for about a year and a half. I also had a certification in helicopter operations and rescue operations, which I ran that school for approximately about 4 years. Repel Master School, ran that school along with helicopter operations.
What training and experience do you have with regard to use of force?
After I left what they call the SOARS Unit, Special Operations and Research Group, I went over to the Practical Applications Unit to train the new agents in techniques that they would need in order to understand tactics better, how to tactically go into a situation for their own survival. I was asked at that point by the director of the FBI, Louis Freeh, to begin a program called the Law Enforcement Training for Safety and Survival. That was what I named it. That was the name I came up with, and he approved it. And that was dealing with our task force agents all across the country. And we had, at that point, the task forces were federally run, but they had local, county, city, state police officers in from the other federal agencies, ATF, DEA, and they were on the task force programs. And in that task force program, and my law enforcement training for safety and survival was all geared towards the survival of those agents and officers in violent crime situations.
And you mentioned Director Free's name. For the record, that's Louisfreeh, is that right?
I believe it is, yes.
All right. When, any other duties in the FBI before you retired from there?
Right before I retired, I was running the Law Enforcement Training for Safety and Survival program and doing a lot of research in there, finishing up my doctorate. And then I retired from the FBI in '99.
In 1999. What did you get your PhD in?
It was an EDD, a doctorate in education, and it's dealing with the human factor of education and psychologically how do they learn, how do they perform, what their actions might be, and how they perceive themselves.
And are you familiar with a man named Bill Lewinsky?
Yes, I am.
How are you familiar with him?
Dr. Lewinsky and I met back when he was in the program called Caliber Press, and he was one of the instructors in Caliber Press. And it was right after what we call the Miami shooting, where we lost 2 agents were killed and 5 agents were wounded. And he made some comments in the program that I did not agree with, and so we had a conversation about that, and we finally met, and I've been friends with him for 30 plus years.
Have you been to his instruction on what's called force science?
Yes, I'm a board member of the Force Science Institute.
Okay. So you know about that?
Yes, I do.
And the opinions that you're going to give here, you're giving notwithstanding that?
That's correct.
Okay. Have you testified as an expert in use of force throughout this country?
Yes, I have.
Can you elaborate on that to the court?
I've testified in court probably 15, 20 times on use of force. And it goes from civil matters to criminal matters. I've done a variety from all the way from California out to up into New England, down to Florida, all over the country.
Qualified as an expert?
Yes.
And you were retained by our office, so you're being paid, correct?
That's correct.
You don't work for free?
That's correct.
Okay. Did you receive a variety of documents from our office, including grand jury testimony, Dallas County Sheriff's Office case summary, Bald Springs Department General Orders Manual, and then a report from Nick Webb as part of your preparation for this case?
Yes, also the forensic video from Grand Fredericks.
Okay. And did you also review material from your own resources in order to prepare for your testimony in this case and prepare your report?
Yes, I reviewed material and material that I've worked with for several years, that just looking back on some of that material.
Have you yourself published and also produced videotapes for your use as a consultant and expert witness?
While I was in the FBI, I produced several different videos dealing with force and arrest techniques. I was in a video, it's called Street Survival, I believe it was, that was produced by a film company out of Sweden. And I did several different articles for the FBI, which was not published outside the FBI. And at that time, the FBI did not want things published outside unless they approved it, and this was for internal reasons anyway.
Directing your attention to the time frame around October of 2017, did my colleague Andrew Chatham go and visit you to see if we should retain you as an expert in this case?
Yes, we talked.
And after my discussions with him and my discussions with you, did we retain you as an expert in this case?
Yes, you did.
Okay. Showing now was marked as State's Exhibit 250. And I asked if you recognize that.
Yes, I do.
What is that?
That's my report. Report and attachments.
Okay. And we've been through that numerous times, including last night.
Yes, that's correct.
And I've previously given this to my colleague, Mr. Lane. I'm going to offer State's 250 for the purposes of this hearing, Judge.
Can I just ask you a question, Judge?
Sure.
Dr. Hayden, this is your amended report. Is there another report?
There's a report that I did before that that I didn't know if it was an official report or not. Then I found out it had been submitted. So when I was reviewing material, I put that in as an amended report so there'd be no confusion.
Well, where is that original report?
The district attorney's office would have that.
Well,
Your Honor, I provided that to the defense previously and told them what the difference is between the original report and the amended report.
that's correct, Judge, between the lawyers, but I'm talking about a record and for you to review, so I'd like to have the original report also marked.
Do you have an original with you? And if not, then I'll take a copy.
I did not have an original.
I've got it upstairs.
Let's just get it marked.
Okay, we'll take care of that. Do you have any objections to the report that you have in front of you, which you, I believe is 250?
Dr. Hayden, another question to make sure I understand. This report, the amended report, is dated January the 17th of 2018, and it has attachments. When you submitted the original report, it had attachments. Did the attachments change, the information in the attachments changed between the original and the amended?
I'm not sure if the one attachment on the documents that they provided me changed or not. I don't know if I had in that original one the Grant Fredericks report.
I'll tell you, you didn't.
I didn't, okay.
May I approach you, Judge?
Sure.
In your attachments, you have material received from the District Attorney's Office, Dallas, Texas, and this is your January 17th of 18 report. Is that all the information that you received?
On this, you talking about the original one or the
Oh, that's your amended.
my amended report? No, I had the Grant Fredericks report also that I relied upon.
But you didn't put it in your report as an attachment.
I guess I didn't.
Okay, what else did you not put in here as an attachment?
That's, from what I understand, everything else should be correct.
Well, you told us that you reviewed the videos, is that right?
That's correct.
Did you put that in here?
In the videos? No, I don't see that that's in there.
Can you think of anything else that you reviewed that you didn't put in your report?
I cannot think of anything else now.
Judge, for the purpose of this record, we don't have any objection to this.
All right. 248 submitted for purposes of this hearing.
250, Judge.
I'm sorry, 250.
250.
Determined to make that 248.
Well, we'll let you do that. You're the judge.
Thank you, Mr. Lane. You may proceed. All of you 250. Go ahead.
That's all I've got at this time.
After reviewing the grand jury testimony, Grant Fredericks report, the other items I mentioned, did you form some opinions about the appropriateness of the defendant's conduct on April 29, 2017?
Yes, I did.
Did you form the opinion that the defendant used excessive force when he shot and killed Jordan?
Yes, I do.
Can you tell the court the basis of that opinion?
It goes into looking at what the grand jury testimonies, what was said in that, the witnesses, what they said, and then looking at Grant Frederick's video analysis. In that, I did not see any reason why Officer Oliver felt like he had a necessity to fire his weapon at all. As he's approaching the vehicle and as he begins to run, you can see Officer Gross approaching the vehicle, and as the time frame goes down from 9 seconds away, 5 seconds away, 4 seconds, Oliver is looking at this, and it's reported that the human eye is better than the video. So the human eye should be able to pick up and scan a lot of different things. And as he's approaching that vehicle, he should be able to see Officer Gross up there. And as he's approaching and he sees Officer Gross is not close to the vehicle at that time, he's walking towards the vehicle. He's approaching the vehicle. The vehicle's not coming towards him. It's backing up. So the only time that he's right next to that vehicle is in that split second when he breaks the glass. Now, during that period of time, Officer Oliver, if he is approaching and he wants to see what Officer Gross is doing, he has to visually be able to look over and see what he's doing. That takes time. And an example I used to use when we teach, I tell our students, put your fingers out in front of you and focus on one finger. And is the other finger in focus? The other finger will not be in focus. That's what the peripheral vision is. And peripherally, you cannot examine what's going on over on that side. You have to actually focus on that to see what's happening at that point in time. If Officer Oliver would have turned and focused on that, it would have taken probably 0.2 of a second for his eyes to shift over and for his eyes to come back, and focusing on it takes even more time. So you're talking about a half a minute or half a second to 3/4 of a second. Now, this isn't a lot of research that Dr. Lewinsky has done, a lot of research that I did, and other individuals dealing in action versus reaction and response to critical situations. So why I'm saying he used excessive force, he would have seen that Officer Gross was not being dragged into the vehicle. He's standing there. He would have been able to see that. If he did not look over and see it, then he's making an assumption that is not true. And using deadly force and using an assumption is not true is excessive. It's wrong. And so it should not have been done.
And unreasonable.
Absolutely unreasonable.
You've been sitting in this courtroom. You heard the testimony of Officer Gross?
Officer Gross, no.
Okay. But you've seen his grand jury testimony?
Yes, I have.
Okay. And from his grand jury testimony, was it part of your opinion that Gross testified at the grand jury that he never felt threatened or that he was being assaulted or was in danger of the vehicle hitting him?
That's correct.
Did you also form the opinion that the defendant intended to shoot his weapon as he ran toward the subject vehicle?
Yes.
What's the basis of that opinion?
The basis for that is on the grand jury testimonies of two witnesses, Jeremy Seaton, who was across the street, and Quincy White, who was right near the vehicle. They both said he was lifting his weapon up as he approached. Now, that, along with the Grant Frederick's video, dealing with time, as I said before, if he would have been looking over at Officer Gross, he would have not had time, and he would not be bringing his weapon up to his shoulder. The only reason he'd be bringing his weapon up to his shoulder because he's looking at the target straight in front of him. You don't bring your weapon up, I've never seen anybody do it, bring your weapon up as you're looking someplace else. You're bringing it up in front of your vision. And so that's why I believe he brought that weapon up at that point, and the shots happened so quick that he didn't have time to look over to the other side.
Do you feel that the defendant had to fire those 5 shots in order to protect his partner, Officer Gross?
No, there's no time that Officer Gross was in danger, so there's no reason for him to fire at all.
Did you feel like the defendant was overreacting to a situation that never rose to the level where deadly force would be used?
Yes, I do.
Do you think that the defendant had to make split-second decisions in order to save the life of Officer Gross?
No, as I was saying before, that he had about 9 seconds from when he started. He got his weapon, he loaded his weapon, he charged it, and he's moving, and then he starts running forward. He has the time at that point to be able to scan everything that's in front of him, and he has time to think about what he's going to do and what his reaction is going to be. You know, am I going to look and see if Officer Gross is really in danger and try to do something to help him, or am I going to shoot to stop the vehicle?
You also rendered the opinion that the defendant had ample time to think about his potential response and what recourse he had. He was out of control and a danger to innocent persons, 5 of which were in Vidal Allen's vehicle. Is that your opinion?
That's correct.
Will you tell the court how you came to that opinion?
Well, here again, within that 9 seconds as he approaches, he has ample time to think about what he's going to do, what his response is going to be. You mentioned Lewinsky, I'll bring him up again, but along the studies that I did and other people have done, when you multitask, it really creates a longer delay, and what you're trying to do is Officer Gross in trouble, or am I going to shoot? What happens in this, you emphasize one or the other, which one do you think is more important? And I believe at this point, he thought stopping that vehicle was going to be more important. And that's why he came in, he had ample time to think about it, and I think he made the decision as he approached.
Passwords.
Thank you. I didn't tell you something I've taught my son to do when he meets any Vietnam veteran, is to welcome them home. So welcome home, Captain.
Well, I think you were also a Vietnam veteran, right?
Well, not in your league.
Yeah,
but I remember
but you were, so welcome home.
Nobody said hello and welcome home when I got on that airplane. When you got out of the FBI, well, let me ask you something. When was the last time you ever arrested anybody?
Oh, it's before I even came to Quantico, so it would have to be back in 1983, right before I left New York.
And in your whole time as a special agent, did you ever have to shoot someone?
No, I did not.
Have you gone over TCO certification for Texas peace officers?
I have looked at different certifications that they've gone through other cases that I've had, and I'm not sure exactly what they are. I couldn't tell you what they are.
You're not sure what TCO requires?
No, I'm not.
As far as training?
Sure right now.
Well, everything I can read about you, you believe that, as all FBI agents do, I assume, that training and planning is the most important part of staying alive on the street.
Yes, it is. Yes.
Well, have you ever looked at the training scenarios for use of force that TCO requires an officer in Texas to go through before he can become certified?
As I mentioned, I can't sit here and say today exactly what they are.
Do you know the different certifications that police officers in Texas have when they go into police work, the various levels that they can go up?
I know there's different levels, master, officer, there's different levels. And here again, I cannot tell you what they are.
Have you ever been a police officer?
I have not.
Have you ever worked the streets as a patrol officer?
I've worked the streets with our task forces, and our task forces is working with police officers of different calibers, state, county, city, and also federal.
Well, I appreciate that. My question was, have you ever worked as a patrol officer, one-car patrol officer on the streets of any city in the United States?
I have not.
Your opinions, as you set them out in your report, would you agree with me that you kind of wrote your opinion and you had a lot of conclusions that you've got from from other testimony out of the grand jury, things that people told after the fact?
Well, when I look at that, I try to look at it in the view of what is happening at the time, not with 20/20 hindsight.
Well, that's what's required.
That is required, and that's what I tried to do. So when I'm looking at the statements that are written, that's statements that are written at that time, and I'm looking at it, what would a reasonable officer that's there at that time look at and say that this is happening right now, not 20/20 hindsight?
Well, I appreciate that, but if you've never been a patrol officer in the state of Texas in a city the size of Ball Springs, how do you form an opinion as to what a reasonable officer would do in Texas under those circumstances?
Because the Supreme Court under Graham versus Connor is what I'm looking at, you know, the reasonable officer standard. And that standard is pretty much right across the line, no matter what state you go to. And that's what's great about our country. Out of all the states that we have, we're all governed basically by the same laws. Now we have state laws and local laws that apply, but the federal law supersedes all that. And that's what we look at in law enforcement. What would a reasonable officer in those circumstances say? Now, the use of force manual that Ball Springs has talks about that. You have to stay within the federal and state laws. So that's what they're saying, that you know, you have to, any action you have would be in that standard.
Well, Graham versus Connor really was a civil case in which the Supreme Court set out what they think you should look at when you're dealing with Fourth Amendment use of force, correct?
That's correct.
And they said that the most important thing is to not use 20/20 hindsight, but only look at what was available to the officer in the split-second decision that he had to make.
I would agree with that.
Is that pretty good?
I would agree with that. They said, it doesn't say, I don't think within the split second, but it says split-second decisions.
And so, but in your report, you talk about that, the way I read it, that Oliver should have known a bunch of factors, i.e. that this was the Banks brothers gang and that they were just shooting up in the air. And you kind of interjected that into your report, but there's nothing that you can find that in anything that you read from Gross's testimony down that says that Oliver knew all of that.
No, what would a reasonable officer know at that time? At that time, they heard what they thought was gunfire, what they thought was gunfire. So they
was
did.
That reasonable?
That was absolutely reasonable, and
was
they
it
did.
Reasonable to believe that it was being fired by one weapon?
It wasn't reasonable to understand one weapon, more weapons. Was it some kind of other alternatives that sounded like gunfire? They didn't know. That's why they went out to investigate. And going down to investigate is what they needed to do.
And that was reasonable for them to do that.
Yes, it was.
Now, we don't look at it from what Gross saw. We look at it from what Oliver saw, correct?
I'm looking at it from what both saw.
Well, but in determining what Oliver, to judge him, we have to look at and try to figure out only what he reasonably thought was happening, correct?
Well, I can't get into his mind what he was thinking at that time.
No, you can't.
But a reasonable officer, what would a reasonable officer think? They heard the gunfire, we went out to examine, and that's what I would think Officer Oliver was doing.
Well, you talk in terms of 5 innocent children and all of that. You agree with me that neither Gross nor Oliver had any idea who was in the car or how many people were in the car.
And they didn't know if they were innocent children or what they were. I would agree with that.
You put that in here, didn't you?
What's that? The
5 innocent children?
Yes, I did.
Well, but that has nothing to do with what Oliver and Gross knew, correct?
But that has nothing to do with it. No.
Well, that's kind of that's what the Supreme Court was worried about, hindsight. 20/20.
Okay.
Agree?
I would understand what you're saying on that, yes.
I didn't ask if you understood. I said, do you agree?
Well, there were 5 innocent children. And from everything that we knew at that time, I don't know what Officer Oliver and what Officer Gross knew, but they didn't know who was in the car. I would agree with that.
Well, unfortunately, we've all found out later other facts that maybe if Officer Gross and Oliver had known, they might, or at least Oliver might have made a different decision, correct?
I don't know what decision you would have made, but yes, I would understand that that would be information.
When I read your report, you said you saw Grant Frederick's video, but I noticed that you say that, or I know talking to people about how you do this stuff, you review everything, you make notes, and then you prepare your report, correct?
Correct.
Do you have any of those notes with you here today?
When I prepare these reports, I do.
I just asked you, do you have any of those notes with you here today?
And what I'm trying to explain what my notes are. My notes are a living document that I'm changing and working with in my computer. So I'm not writing hand notes on it. I'm writing the computer, and if it applies, I apply it in there. If I take it out, so it's kind of a living document. So I do not have any handwritten notes.
Well, you agree with me that the information that was available to Officer Oliver was that Officer Gross was trying to stop and detain a vehicle.
That's correct.
And you agree with me that when that individual, and you know from reading the grand jury testimony that the driver knew that there was a police officer there telling him to stop the car, correct?
That's correct.
And you agree with me that when he didn't stop the car after being told to, commanded to by an officer in uniform in his city, that he was violating the law by driving off, correct?
That's my understanding.
You agree with me that he was committing a felony when he did that?
That's my understanding, it is a felony.
Did you go over the Texas Penal Code prior to the time you made your report?
I looked at it, but I'm not an attorney, so I'm not looking at it as a legal person.
Well, did you look at the statute dealing with murder?
I'm not sure if I did or not.
Did you look at the statute that deals with self-defense?
I don't know if I did or not.
Did you look at the statute that deals with the defense of another?
I don't know if I looked at that or not.
Did you look at the statute that deals with reckless conduct?
I'm not sure if I did or not.
Judge Gill reminded me that I should ask you if you have any computer notes that you prepared in anticipation of your report.
Computer notes as far as what?
Well, you said you did your notes on a computer. I mean, do you keep that?
Well, as I was saying, my report, when I'm writing my report, it's a living document. So I'm continually working within that document and changing things. So I might have something in there, then I take it out. So I'm not keeping, every time I make a change, I'm not keeping those changes.
Do you have anything that backs up the original document that you were creating with the notes?
I can't think of anything I do have.
I'm almost through. Let me ask you if you could just for, there's a wonderful DA over in Fort Worth, and when you start talking to him, and these other two gentlemen here work for that DA, I just happen to know him, used to say, can you get the hay down here where the pygmy goats can read it, can eat it? Can you tell us what your opinions were? The first opinion do you think is the most important?
I was never a farmer, so I don't know how the pigs eat my whole life.
Well, these goats. Got to get the hay out from way up high down here where us people can understand. What's
So
your first most
if you could bring it to New York language, what is it you're asking?
What's your first opinion?
My first opinion that as the Officer Gross and Officer Oliver came out of the building, they heard the gunshots. They came out of the building, they were doing a good job. They were doing what they should be doing. They were investigating what was going on up at that area.
Well, by the way, if you looked at the videotapes, you saw that Officer Oliver and Gross were actually interacting with those kids at that party.
Yes, I thought they were doing a good job. I had no
Good
problems
police
with
work.
what they were doing at all.
Did you see any indication to you as an individual who's offering an opinion that Officer Gross or Officer Oliver was mad at anybody at that point?
I saw nothing like
Pushy?
that. I saw nothing like
Good
that.
police work.
Yes.
All right. That's one. Go for the next one.
So as they came out, they were doing what they should be doing. And then when Officer Gross was telling the vehicle to stop, he was doing what he had a right to do. He was trying to stop that vehicle. When he pulled his weapon out, that was a little bit overreaction. Why was he pulling his weapon out? And he would have to explain that.
Well,
And I'm not saying it's right or wrong. I'm just saying I looked at it like, why did he pull his weapon out at that point in time?
okay. You're not criticizing Gross?
I'm not criticizing Gross at that time. I just don't know why he did it.
Well, let me ask you something. Could it have been that Officer Gross saw something that was dangerous?
It could be that, but I didn't see any indication of anything in his grand jury testimony that said that.
Well, you sure saw that he pulled the weapon out,
Yes, I did.
pointed it at the vehicle.
I don't know if he pointed at the vehicle. He used it and he hit the back window, and it broke the window.
Well, it'd have to be pointed for him to break, hit it.
Not necessarily. He could have hit it just on the side, so.
Did you hear any testimony about him hitting the window on the side?
I heard him when he pulled his weapon out, he hit his weapon on the window.
Okay. Next opinion.
Next, is after Officer Gross broke the window, the next thing that we hear is the shots. And I thought those shots were totally inappropriate. They weren't necessary to protect Officer Gross' life or protect him in any way or to protect Officer Oliver. And he shot 5 rounds, and I did not see any reason why he needed to shoot round 1 or 2 or 3 or 4 or 5.
All right. Next opinion.
And that's pretty much where I ended up.
And you used your knowledge of Brown versus Connor to make those decisions?
That's one of the things I use, yes.
What else did you use?
Tennessee versus Garnet, escaping felon. All the information that I looked at, the thousands of police officers and law enforcement officers I've worked with over my years in law enforcement, and especially when I was developing the program for the Law Enforcement Training for Safety and Survival, the hundreds of police officers I talked to that had been in shootings, had been shot at or shot at other people, and so a lot of information that I developed over the years.
Is that all of your opinions? Is that it?
The only thing that I did have added into there was when they went down when the car was stopped on Bishop, is that Officer Oliver coming down there assisting on that. The policies and procedures, it's pretty well understood in law enforcement. If you've been involved in a shooting like that, you don't contaminate another area.
Did you review the general orders for Ball Springs?
From that, I don't know if I saw it in there or not.
My question was, do you remember reviewing the general orders for
Yes.
police officers in Ball Springs?
Yes,
Is that where you got that information?
I believe it is, but I'm not positive.
Do you remember their use of force, general orders?
I remember seeing their use of force, and
And did you factor that into your opinion?
yes, I did.
Because he would be required to follow those general orders, correct?
He'd be required to follow if they fit within the law enforcement standard for use of force.
If the general orders follow?
The general orders for Ball Spring, there's no problem with that. I think it falls right within that. That's not a
And
problem.
the general orders there, of course, has a provision about shooting into a vehicle that is being used as a deadly weapon and dangerous.
Well, there's 2 things about shooting into a vehicle. One is that they say don't shoot a vehicle because you're not going to stop it. The other is shoot an individual to stop the vehicle. But you have to look further back into that. Is there a reason to believe that you need to stop that vehicle? shooting an individual or shooting a car is most likely not going to stop that vehicle. So the danger that has occurred or going to occur is probably still going to occur if you shoot the vehicle or you shoot the individual in the vehicle. So there's pretty much the standard within law enforcement. You don't shoot at a vehicle unless there's such extenuating circumstances that you feel like you have to save your life or the life of somebody else.
Did you go out to the scene?
Yes, I did.
When did you do that?
I think it might have been in December. I might have come out to the scene.
And did you personally interview anyone?
No, I didn't.
Do you know how many times you visited with the district attorney's office?
Personally, when I was out there visiting the scene, I was with Mr. Snipes, and then when I came back this time, so it's the only times I've physically seen him, but I've talked to Mr. Snipes several times on the phone.
Well, you certainly didn't win any awards in Vietnam. You were awarded those awards based upon your conduct.
That's true. Absolutely.
And I'll tell you.
And I was surprised that at West Point would say that.
Yes, I was too. Thank you. That's all I've got.
Any other questions?
Just to offer the original report, Judge.
Thank you. Go ahead. What number?
States 280.
States 280 is the original report we referred to earlier.
Yes, sir.
Do you have any objections for purposes of this hearing?
Yeah. No, not for the purpose of this hearing.
280 is admitted for purposes of this hearing. Thank you.
And that's all I have, Judge.
All right, sir, you may, I believe. Do you have any questions, Mr. Lane, at this time?
Not at this time.
Okay, sir, you may stand here. Thank you. Please be careful on your way down. Mr. Snipes, you're submitting this witness as an expert witness to give the opinions that he's proffered this morning.
Yes, sir.
All right. You wish to hear anything further on that? Yes, not. Mr. Lane, do you have any objections?
Judge, we have a running objection about the Garrity information, and I think when you look at the attachments, you'll see that he reviewed the Dallas County Sheriff's Department case report, which we maintain was a product of Garrity.
Yes, sir. The objection is noted. I will overrule your objection based on tainted Garrity information for this witness.
And we have that running objection when he testifies.
You will have one objection to that? Yes, sir.
Thank you.
That's it?
Yes, sir.
All right. Is there anything else we need to take up? I'm sorry, there's two other matters. Mr. Gill, yesterday you informed the court that you had a motion to dismiss the prosecution of this case. If you wish to be heard on that, I'll allow you to do that, and I'll let anybody from the state reply if they need to.
Thank you, Your Honor. And this is something that was brought up verbally during the course of the Castigar hearing we had a couple of days ago.
Yes, sir.
And at that point, I mentioned I would be filing a written motion to dismiss, and I have now done so, and a copy's been served on the DA's office. And we have two grounds on the motion for dismiss. One is the taint of the walkthrough Garrity statement given at 5:20 a.m. on April 30th of 2017, and one is the taint from a written Garrity statement given by Mr. Oliver to Ball Springs Police Department on May 2nd of 2017, which was then delivered by Ball Springs down to the DA's office, and that's the statement that their investigator read, and they say they have cordoned off from the rest of the office. So we have two bases for the motion to dismiss, which were the same two bases we brought up during the hearing. I've just now filed a formal written motion.
I have reviewed the motion. The motion to dismiss these indictments is denied.
And are you denying it separately on both grounds, Judge?
Yes, sir. Separately on both grounds.
Thank you.
Is there anything else we need to take? There was a stipulation regarding the finger gesture that you guys are going to work on at some point. Did y'all work something out, Mr. Snipes and Mr. Brissett?
Mr. Brissett was going to work on it. He hasn't given it to me.
I haven't given it to him yet. I wanted to get through the hearing, so I'll have it if it's here today or here tomorrow. It'll be before the conclusion of the state's case in chief.
And the last that I had was a motion for the introduction of extraneous conduct from the state. which I'm not going to take up at this time. I'll take it up at a later time. Is there anything else from your side before we recess for the rest of the morning until we start at 1 o'clock?
Nothing from the state.
It may be 1:15. I can't remember exactly when the jury will be there. Everybody back at 1 o'clock. Thank you all very much.